I'd like to welcome Ron. How are we doing?
Doing great, Jeremy. Thank you. Thank you.
I'm excited to do this with you.
Me
Um,
too. I love working with your firm. Boy, you guys are the best.
Same here, same here. Um, and speaking of that, we're continuing our best practices seminar series that we're doing at our firm. And of course, when we are thinking about topics that come up for co-ops, we are seeing a prevalent situation where we have shareholders apply to have their shares transferred into a trust. So we knew this was going to be one of the topics that we tackle for our best practices webinar series. And when we knew that, it took us about a fraction of a second to decide who we should collaborate with on this. And that was Ron Fatula of Ronald Fatula and Associates, one of the premier trust and estates firms, very well known, very respected. And to speak about this topic and to speak to our clientele and to speak to our colleagues in the field in regards to trust transfers, we need to know the basics of trust. So the first half of this webinar is going to be heavy with Ron, and Ron is going to explain to us what trusts are and the trust basics. And then later in the webinar, I'll explain and talk about the process of when a board does receive an application, what that process and what the protections are that a board should have. Sound like a plan, Ron?
Sounds like a plan to me. Thanks, Jeremy. Sounds great. And by the way, if anybody has any more detailed questions, feel free to ask later on.
Okay. So Ron, what is a trust?
Well, we got to start with the basics, Jeremy. So what is a trust? Trust is an entity, like a corporation, but it's not a corporation. It's a trust. So the entity is called a trust, and it's created with a trust agreement. So the attorney, we're trust and estates and elder law attorneys, we create a trust agreement that sets forth all of the rules of the trust. And it creates this entity that holds assets. And those assets are managed the way we draft the trust for our client. So if we're drafting a trust for Medicaid purposes, we will have the assets in the trust, namely, tonight we're talking about a co-op, managed a certain way and be able to be distributed a certain way. So the assets in that trust are managed depending on what our goals are, whether it's trying to save on estate taxes or protecting the co-op for Medicaid purposes. But, we draft each trust agreement a little differently. When we draft this agreement, a lot of clients ask right away, well, if this is a separate entity, so just like it's a separate person in a sense, it's going to need its own tax ID number. And that's not true with a revocable trust. And sometimes it's true with an irrevocable trust, depending on how we draft that trust. So again, a trust is simply an entity that holds assets that are managed in accordance with the way that we set it up. And we set it up differently depending on what the objective is of our client. So next slide.
Who are the parties to a trust?
So yeah, the parties to the trust, well, let me backtrack. The attorney would draft the trust based on what the objective is. The individual that we see, our client, is typically the individual that creates the trust. And the law has three names for that creator. Number one, funny enough, the the creator. Number two, the grantor. And number three, the settlor. All interchangeable. The individual that creates the trust. The trustee is the individual or individuals, plural, that manage the assets in the trust according to the strict rules that we create, depending on what our client's objective is. And this is the part everybody wants to be, is the beneficiary. Whoops, I think we lost our slides, but I can talk while we get the slides up. The beneficiary could be an individual. It could be a charitable organization. It could be an entity. Or many times it's another trust within the trust. So let's say the co-op is held by the trust. You're the grantor. You might be the trustee as well. You might name a child to be the trustee, or a brother or sister. Who are the beneficiaries? You might be a beneficiary initially during your lifetime. And when you pass away, you might give the co-op, make your children the beneficiaries. Those are individuals. Or it could be a charity, or it could be part your children, part a charity, or an entity. But many times, for example, if a client has a disabled child, they want to keep the co-op in the trust, possibly for that disabled child. So there's another trust that would be continuing. Or if the co-op would go to grandchildren, and you don't want the grandchildren to actually take title right away, we might have a continuing trust. And so the question is, or Jeremy, you could ask me, but the question is, how do we create a trust? Well, again, we create it through a trust agreement. And again, every single trust agreement that we do is a little bit different, depending on our objectives, but also depending on our client's situation. Their family structure, are they concerned about fraud, undue influence? Do they get along with their children? Do they not get along? Might one child come, surface later on and contest what the individual did? Believe it or not, you can contest the trust. It's not as easy as a will, but it's possible. So we take all of that information, put it together, and we figure out the best way on how to draft that trust for our client. Now, a lot of people don't realize that in order to have an asset be subject to the terms of the trust, be actually in the trust, you can't just simply assign, you can't just say, oh, I assign everything I have into the trust. That doesn't work according to the law, according to the EPTL, the Estates, Powers, and Trust Law. You have to specifically assign the co-op, the shares. Co-op is Jeremy knows this like the back of his hand, so we're gonna leave that to him. But you actually have to do the assignment of the shares and the proprietary lease into the trust. And then the trust will control. So it won't happen until there's an assignment specifically. And that's like a general assignment won't suffice. A specific assignment would. Next slide.
That's important for attorneys who draft trusts. You could draft the trust and include the co-op, but you do need to engage the co-op, the board, the management, and send in that application to have the shares issued in the trust's name.
Jeremy, you're absolutely right.
So it's not just done with the trust.
That's right. So, Jeremy, I can't tell you how many attorneys, they may be smart. They draft a great trust, and then they leave their client, on their own, and they say, okay, put the co-op in the trust, do this, do that. And, the bottom line is, so many times we see with lots of other attorneys, the co-op isn't held by the trust. So that trust could just be a worthless piece of paper. You have to take that extra step. Jeremy, thanks so much for reiterating that. It's very important. And so there are just so many different types of trusts. We have trusts that are in wills. So we could draft a will for you and actually have a trust within that will that says, well, when you pass away, the assets don't go directly to a beneficiary. It might be held in trust for that beneficiary. And that type of trust that's held within the will is called a testamentary trust. Second bullet point, we might draft a trust to protect the co-op and other assets for Medicaid purposes. The cost of long-term care is astronomical. The cost of a nursing home on average in New York City and Long Island is about $16,000, $17,000 a month. And we certainly don't want anyone to become impoverished. There are ways to protect your assets, your co-op, and the Medicaid Asset Protection Trust is by far the gold standard and the vehicle to protect your co-op or home, actually. There are trusts that can eliminate or reduce estate taxes. Right now, we have a very high exclusion. The exemption is 11.7 million. But President Biden has been talking about reducing that to 3.5 million. And that 3.5 million could even, at least right now it does, include life insurance, your retirement accounts. It could really add up. So you do have to be careful. President Biden is also thinking about changing capital gains taxes. And so that's something that we have to look at. It's just a proposal, but it's something to look at. And we want to use these trusts, yes, to eliminate or reduce estate taxes, but also look at capital gains taxes and try to game the system. We're lawyers. Everything we do is legal, but we want to use the law to protect you as best we can. Trusts can be revocable or irrevocable. So revocable trust just simply means that it's a trust that you could revoke, you could amend, you could say, I don't want it anymore. And that's fine. An irrevocable trust is a trust that on the surface, you cannot amend or revoke it, but you can, and we're going to get to a slide on this in a little bit, but you can in certain circumstances. Pretty funny. I mean, when I tell a client, they said, well, it's an irrevocable trust, so I can't revoke it, Jeremy. And I know we had this conversation last week. So many times I tell my client, yes, it's an irrevocable trust, but you can revoke it, and we're going to actually draft it with the general power of appointment. It's a legal terminology, so that you probably can revoke the trust. So they say, so you can revoke an irrevocable trust? Sometimes you can. Usually you can.
This is a common question I get from our clients when they're considering an application. Does it matter to the co-op if it's irrevocable or revocable?
Right. And Jeremy is going to, look, Jeremy is there to protect the co-op and to protect you guys as well. And, wants to make sure that the co-op's going to be protected. So his firm is amazing. I mean, they are the go-to, and they will do everything they can to protect the co-op, and so we could draft the best trust for our client, but then once it gets in Jeremy's hands, or Mark or Jeff or whoever, at the firm might be involved in this, they might say, well, Ron, no, we need this, we need that, we need this, we need that. I said, really? and they'd say, absolutely, our client is a co-op, this is what we need. So they have your back, and but they work with us. And, it is going to be a win-win if we could protect your assets vis-a-vis Medicaid, or save on estate taxes, avoid probate, and have Jeremy or Jeff or Mark be there for you and do what has to be done to protect the co-op as well. So I look at it as a total win-win.
Agreed. We're
Yeah,
looking for that happy medium.
exactly. And we achieve it
Yes.
almost all the time. Actually, I think lately it's pretty much all the time. I think we've got it down at this point. So anything within the trust actually avoids probate, because you're going to name the beneficiary in the trust. So you don't have to go to probate with your will vis-a-vis any assets that are held by the trust, including the co-op, which is great. There are spendthrift trusts, a little bit different. We're going to talk about spendthrift provisions in the trust, but sometimes you might be concerned about, let's say, a child who can't hold on to money and just spends the money incessantly, and you don't want to give that child assets, maybe the co-op outright, because he or she might just sell the co-op, lose the money, go to Atlantic City or whatever, and you may want to set up a spendthrift trust only vis-a-vis that child or that individual. We're going to talk about spendthrift provisions in the trust later on. If there's a child or someone else with special needs, upon death, you may not want the co-op to go outright to that child, or other assets outright to that child. It might be held in a continuing special needs trust to protect the benefits that that child might be getting, which might be SSI, Medicaid, etc. The trust could also provide creditor protection. This is what I mean. Many clients come to me and say, well, I want to transfer my co-op to my son directly. Whether or not the co-op board would approve a direct transfer to a child that may not live in the co-op is questionable at best. But what about creditors that child may have? We had an incident, Jeremy, you might find this interesting. My client came to me and said, I trust my daughter implicitly. Transfer the home. It wasn't a co-op. Transfer the home to my daughter, and I trust her implicitly. I don't care. And said, we don't need a trust. So I said, I really would prefer the trust. They said, no, we don't want a trust. We just don't want to get into it. I said, okay. Her daughter was involved in a car accident on Queens Boulevard in Forest Hills. And it was an awful crash, leaving someone a quadriplegic. And she was sued. The insurance, the bodily injury insurance on the car, it all maxed out, so that she was sued. The co-op was transferred to the daughter. Other assets were transferred to the daughter. She was sued, and all of the assets were lost. So that's the sort of creditor protection I'm talking about that trust would give you. If it was held in a trust, daughter's in a car accident, someone sues her, she gets divorced, whatnot, the co-op and other assets that may be in the trust are protected. And we may also want to provide for minors trusts. Let's say upon death, you want certain assets, possibly even the co-op, to go to grandchildren, or a grandchild. Well, that might be fine. If that grandchild is 18 years of age, maybe that may not be the best idea. You might sell the co-op and buy a Corvette or Ferrari or whatever the hot car is, at the time. May not be what you want. So we can have this continuing trust to protect the co-op and other assets. Next slide. Okay, so, well, actually, I think I covered a lot of this in the prior slide, but why would we want to transfer co-op shares to a trust? For Medicaid purposes. You want to get your assets down for a lot of reasons. There could be Medicaid recovery, even if the co-op is exempt from Medicaid, and it is sometimes for Medicaid home care. When you pass away, Medicaid's going to recover against the co-op. This is where the trust will protect the co-op, not only for you when you apply, even when you die, to avoid a Medicaid recovery, avoid that Medicaid lien. It avoids probate. Again, we could eliminate estate taxes or reduce estate taxes. We do estate planning. And with the trust that we draft, we could retain the capital gains tax exclusion, even though it's when for Medicaid purposes, you get the co-op out of your name. It's in this trust. Let's say you want to sell the co-op. Well, even though you don't own it in your name, we draft the trust in a certain way so that the IRS will say you own it. So you will get the $250,000, or if you're married, the $500,000 exclusion for capital gains, IRS Code Section 121A. If you die, you'll get the basis step up. So if you bought the co-op for $100,000, and when you die, it's going to be worth $1 million, the basis, for tax reasons, gets moved up to the value at the time of death. But for Medicaid, it's out of your name. So it's sort of like magic. For Medicaid, that co-op is out of your name. You get all of these protections, but for IRS purposes, for what you need, to get the $250,000 or $500,000 exclusion from capital gains, well, you get it. Basis step up, you get it. And don't forget, we don't know what's going to happen, but President Biden has proposed changes to the basis step up rules, but he did propose an exclusion when you die of $1 million and an extra $250,000 for your home, co-op, or condominium. Next slide. Okay, so Jeremy, I think this is where you start, right?
This is still you, but you know what we
Oh, it's
discussed?
still me? I'm happy to
We
whatever you want.
discussed this question. Should a board care if it's revocable or irrevocable?
I say no. What do you say, Jeremy?
I say no as well.
Good.
And
Good.
even the irrevocable, as you explained, could be set up
Right.
to not be so irrevocable. And we'll get into, of course, Ron references in his slide right here about safeguards in place, which we'll get into. So Matt, what do you have as the next slide?
Okay, so I guess this is my slide. So yeah, so I did touch upon this before. Revocable trust is by nature. A revocable trust is revocable. You could amend it. You could change it. You could say, I don't want it. You could change the terms, do whatever you want. An irrevocable trust on its face is irrevocable. I referenced the Estates, Powers, and Trust Law 7-1.9, which says that if you have an irrevocable trust, you can revoke it. You can modify it, but you need the consent of the grantor, the trustee, and all the beneficiaries. And the beneficiaries can't be minors, like even grandchildren under the age of 18. So how do you do this? There's a trick that we do. We put in a provision called the power of appointment, so that you could simply say, oh, all of a sudden, like magic, I changed in this irrevocable trust, I changed the beneficiary to be my son, who's the trustee. And all I need is his consent. So even with an irrevocable trust, you can, in almost all instances, revoke that, modify it, or amend it. But the safeguards that Jeremy will talk about to protect the co-op will be there. That doesn't go away, just because we could permit this change. You can't change that because that's contractual.
And
Next
I like
slide.
I like hearing that it can be amended, because if I do see something, a trust application and something within the trust that I find very objectionable, um, maybe an additional agreement wouldn't satisfy me, and maybe I would want them to amend their trust before this application could be approved. So I'm happy that, they should be able to amend it.
That's right. That's right. What we do, I mean, everyone should know, for our clients, Hankin and Maisel represent so many boards because they're so good. And so what we typically do is we draft the trust. I go over the trust with our client. We work everything out, but we don't have it signed. We then go to Hankin and Maisel. This is what we want. So it's not signed. We don't have to actually amend it. And then Jeremy or Jeff or Mark will say, well, this is fine, this is fine, this is fine. But you know what? We need X, we need Y, or I want you to change X or Y. So our trust isn't done yet. We just
Very,
did a draft.
very, very important point, and very smart point. I'll receive trusts in the applications that are dated 2 days before, executed, signed. And I always think to myself, why did you bring your client in to date it and execute it, sign it, notarize it, have witnesses come in, and then present it to the co-op? You should have a draft, a working draft, and present that working draft to the co-op. Once everything is in good order, that's when you should bring your client in to sign. And I'm not surprised that Ron Fatula's office does it the right way.
Right. Thanks, Jeremy. Thanks. Well, actually, I already touched upon this. So you actually have to specifically assign the shares and the proprietary lease into the trust specifically. And then Hankin and Maisel will actually, along with the managing agent, get the co-op shares to reflect the ownership in the name of the trustee of the trust. Okay, next slide.
Okay.
So
Now,
I think you take it away, Jeremy.
sounds like a plan.
Okay.
Now that we have the basics of what trusts are and their purpose and how they are formed, which, by the way, I have a feeling Ron's going to get a lot of phone calls, because I think everyone's looking at those slides and thinking, oh, let me think about my own estate planning. Let me think about my own estate planning status, and look at all these benefits that come from trusts or other estate planning tools. So I know I'm thinking about it, so I'm sure everybody out there is thinking about it also. So again, we are being presented as a co-op with an application to have their shares transferred into the trust. So we need to be protected, and the question is how. And I like to say that the goal is the status quo. We're not asking for more, we're not asking for less. So what is the status quo? Max, let's do the next slide. Okay, let's talk about the co-op's governing documents. When I say governing documents, that's a catch-all term. So that'll include your offering plans, your proprietary lease, your occupancy agreement, your house rules, your bylaws. Governing documents is a term that we use to encompass all the co-op's rules. Most importantly, we talk about the proprietary lease or occupancy agreement. I want to give a quick reminder that these documents form a landlord-tenant relationship between the co-op, who's the landlord, and the shareholder, who's a tenant. And that document gives the shareholder the right to possess that particular unit pursuant to the terms of that agreement. So, these documents were created a long time ago, and they simply did not anticipate or trust ownership. So, we have a document, and it's really for individuals. And like Ron said, trusts are not individuals; they are entities. So now we're entering into a relationship with an entity. What does that mean? And of course, most common forms require that the co-op unit is to be used as a private dwelling and to be occupied by the shareholder and their family. Of course, a trust is an entity, and they can't physically occupy a unit. So you run into, that's one of the first things that come to mind when we're thinking about these applications. And now the question is, how do we tackle these issues? So Max, let's go to the next slide. These are protective agreements that we've used at our firm. We have an inducement agreement, a guarantee agreement, an occupancy agreement, a designation of agent, and an attorney opinion letter. I'm going to go through these agreements one by one and go from there. Max, go ahead. Here's the inducement agreement. So the inducement agreement essentially talks about obtaining consent. We all know that each transfer requires the consent of the board. So the board will be presented with this application, and they're going to say to themselves, why should we accept this application? And nowhere in these proprietary leases or occupancy agreements does it say you have to accept an application to a trust. So we put that in writing, right in this inducement agreement, that the shareholder acknowledges that the corporation is not required to issue shares of the corporation or assign the proprietary lease to a trust under the provisions of any of the corporate governing documents. Also, this inducement agreement is being executed in order to induce the corporation to grant its consent to proposed transfer. So you, the shareholder, are inducing us, the corporation. We are only going to accept your application if you agree to these terms and you agree to sign these agreements that we've put in place. The grantor and the trustee recognize that the corporation is relying upon these representations, covenants, and agreements set forth in this inducement agreement and the other instruments executed in connection with this agreement in permitting a transfer of the shares in the lease to a trust, and that the corporation would not otherwise consent to such transfer. So it's not the corporation's idea, it's not the board's idea, it's the shareholder's idea. The shareholder has to play by the rules, agree to these terms, sign these agreements, and then we will consent to this transfer. So that is the inducement agreement. Let's do the next slide, Max. Guarantee agreement. Okay, again, the proposal is that a trust, an entity, becomes the shareholder. So who's on the hook now that the trust entity is the shareholder and lessee? Again, status quo. We had individuals who were the shareholders and who were living in this co-op unit. So if the shareholders were responsible to guarantee the payment and the performance of the lease and occupancy agreement, then those people will continue to guarantee that performance. And I've included excerpts, buzz sentences from these agreements on these slides. And this one here is: shareholder personally guarantees unconditionally and irrevocably the full and punctual payment when due and performance of all obligations of the trust arising out of the ownership of the shares and/or out of the lease of the apartment. So shareholder still on the hook, personally guarantee. That's the guarantee agreement. Next, Max, please. Occupancy agreement. After our first thought of money, of course, next comes, well, who's going to live in the agreement? If we consent to a transfer to a trust entity, does that mean anyone could live in the apartment? The answer is no. Not if you sign our agreements, which you have to. Who gets to live in the unit? Again, status quo. If John Doe is the shareholder, then the apartment shall not be occupied by any party other than John Doe, together with such persons as would be entitled to occupy the apartment pursuant to the explicit provisions of the lease concerning permitted occupancy, as if John Doe individually was the sole lessee under the lease. So, an important verbiage in there is that, of course, our proprietary leases and occupancy agreements allow for the occupancy of the shareholder, but it usually does allow for the occupancy of the shareholder's family. And again, status quo. We don't want more, we don't want less. So, our agreement specifically states that anyone who was the shareholder would be able to live there, and their family as well, just as if the individual was the sole lessee of the lease. And the occupancy of the apartment by any other person shall require the prior written consent of the corporation, as it usually would. Those are the rules. So again, we're keeping it status quo. We're putting it all in writing. And that's how we protect the co-op. Next slide, please. Designation of agent. So most of our proprietary leases and occupancy agreements, our leases, really establish that you can serve the lessee at the unit. This document is, more of a belt and suspenders document. We are dealing again with a trust entity. So who do you sue? Now that the trust entity is on the shares, how do you sue a trust entity? Well, we're going to expressly establish who and where service of process can be obtained. So there is no question about it. We're going to put it in writing. And that's why we use this document in our batch of documents along with the others. So let's go to the next slide. Attorney opinion letter. We want an attorney to represent an attorney like Ron to tell us that the trust that we've been presented with is validly existing under the laws of the state of New York, that the trust has legal power and authority to enter into these agreements, that the trustee is authorized to act on behalf of the trust, and that the execution of these agreements by the trustee constitute binding obligations of the trust that are enforceable. We want to make sure that this trust agreement we've been is not, and that the proposal is what it is. It's legal under the state of New York. So we have to present that to us. And that's kept in the file, and that gives more credence to the application. Ron, do you have anything to add about attorney opinion letters when you provide them?
Not really. I think you covered it well. We typically don't have a problem with it because you only ask us for something that's reasonable. So not really. I think you covered it well.
Okay. And now this brings me to one of the topics we were discussing earlier. Max, you can go to the next slide. Spendthrift provisions. co-op attorney must review each trust agreement to make sure that there are no problematic provisions for the co-op corporation. And Ron, why don't you tell us what spendthrift provisions? Oh,
Spendthrift provisions. So
besides
basically,
a tongue twister, what
oh,
are
it
they?
definitely is a tongue twister, that's for sure. So these spendthrift provisions are provisions within the trust that protects the trust, the assets of the trust from creditors, so they can't sue. But I mean, it's great for our client, but the co-op recognized, and Jeremy and Henkin and Maisel recognize that if we have these provisions in the trust, it might stop the co-op themselves from satisfying a valid claim that they might have against the trust or even a beneficiary of the trust. You know, so that's the issue. I mean, I love these spendthrift provisions. Say, you know, you can't sue. You know, it's in the trust. But it's not good for a co-op from a cooperative perspective. So those terms vis-a-vis the co-op need to be negated, and we get that, and that makes sense. The co-op needs to make sure that they're going to get their maintenance fees. Let's say there was some negligence and common areas were damaged, or I'm sure, Jeremy, you've seen and heard everything, which I haven't vis-a-vis co-ops, but you need to have a vehicle to go after an individual if you have to. Basically, yeah.
A co-op can be a creditor. So if
Yeah.
these spendthrift provisions protect the shareholder from creditors, well, that's us. And that's not going to fly because then we're not keeping the status quo. You're getting an additional protection that you're really not entitled to under the proprietary lease or occupancy agreement as you would as an individual.
Right. And, you know, just to clarify, so the spendthrift provision, I'm fine with it as long as it's vis-a-vis the corporation, you know, but Joe Blow, someone else, I really, you know, would like some of those protections for our clients, but vis-a-vis the corporation, we will give that up so that the co-op corp has carte blanche. You know, you got to follow the rules, you got to pay your maintenance, etc.
Okay, and we'll bring it home. Max, the last slide, I believe. All right, we go back to our initial question, which is, can co-ops trust trusts? And I think Ron and I are in agreement here in that if a co-op provides the necessary protections with the appropriate agreements in place, trust ownership can provide a substantial benefit to a co-op's shareholders with little or no exposure to the co-op corporation.
Yeah, exactly. And so I look at it as a true win-win. We don't give up much, but the co-op is totally protected. And, you know, it's interesting, Jeremy, I've been practicing longer than I'd like to admit. So over 35 years, and never once has a co-op had an issue, you know, and lately, you know, the last, you know, 10, 15 years, you guys have really stepped it up and really protecting the co-op boards and the co-op corporation, but it is a win-win. So you're totally, in the way I look at it, very minimal exposure. I've never had an instance. But our clients get to use a trust and get to have all of the protections from that trust. So again, I always look for the win-win, and I think this is one of those win-win situations.
Agreed. I think that our presentation is running just on time. Max, how would you like to handle any questions?
Would you like me to ask them to you guys, or would you like to read them yourselves?
Why don't you ask them to us? Because I don't think I see it on my screen.
Me too.
So I'm going to stop sharing. I'm going to stop sharing now. All right. So the first question comes from Marcia Stecker. Marcia asks, in reviewing applications to change shares into a trust, what are some of the items we should focus on in the application?
I would think, first of all, who the parties are. I think that's important. Of course, most likely the grantor, settlor, and creator, right, Ron?
That's it.
Is the shareholder. And, it would be important to see who the trustee is, who is going to act on behalf of the trust. Ron, what else would you look for?
Well, basically that's it. I mean, it's the grantor is the current shareholder. They typically come to my office and say, I'm worried about, want to do Medicaid planning or estate planning or avoid probate or whatever. And, but once it goes into the trust, the trust owns it. And basically it's truly the trustee of the trust that's crucial. And in fact, when we transfer with a co-op the deed, or I'm sorry, with a condo, the deed, or a co-op the shares, the owner is really the trustee of the trust. And that's the individual that, has the control. So you would want to look at that. And, Hankin and Maisel is representing, you would be looking at the trust and reading every provision that we have in there.
Max, go ahead. We're going to do a rapid fire.
Rapid fire. You got it, Jeremy. So Lila Merritt asks, if my apartment is in trust, will I still get my senior tax benefits?
If that trust is drafted correctly, you should be getting your senior citizen tax benefits, absolutely, or VA benefits, whatnot. Yes, you should.
Excellent. Mary Millen asks, our co-op has not accepted trust since our occupancy agreement says that the shareholder must be a permanent resident and the trust cannot be a resident. However, would like to know how much more work is it for a board when dealing with trusts?
So in my opinion, it's not more work. And, there are co-ops out there who do not allow trusts, and, they haven't for years and years and years. As the years have progressed, more and more trusts, co-ops have been open to allowing trust, which is why we're here today talking about it. So it's become more and more prevalent. If your co-op is going to think about it, you're not the only one. And again, our agreements we spoke of dealt with occupancy. So that issue would be tackled with protective documents. So, I've seen the progression from a co-op not allowing trusts to allowing trusts and developing the process of protection. So it is possible for your building.
Excellent. Robert Chasen asks, does the guarantee agreement mean that the trust does not have to have the assets required to pay maintenance on the co-op?
Yes, it does mean that because the shareholder is going to personally guarantee the maintenance. So, of course, this question would only come up practically if they started to not pay. But even in the case that they didn't pay, not only would the trust be on the hook and the trust assets, but there's the personal guarantee as well.
Yeah, and I might just add, if you don't mind, Jeremy, yes, you get the personal guarantee, which is what you had before. So I think the co-op is in the same place it was beforehand. But again, a trust might hold plenty of other assets. So you have the individual who's personally guaranteeing, and the trust is not usually a shell trust. Might have the co-op and other assets. You also have the trust as well to go after. So I think you're in at least as good of a position as you were in beforehand.
Excellent. The next question is from Young Kim. As a co-op, can we ask to put in a provision that allows the co-op to take over trust as a backstop if no beneficiaries are available?
That's not the way the trust works. The trust agreement will have, if your beneficiary is no longer living, you would have successors. And if you want the assets to go somebody to a different person, we could have powers of appointment, but we're going to actually resolve that within the trust document itself.
Okay. Violetta Unitan asks, how can a bene of the trust continue living in the co-op unit after the death? The settler's death, sorry.
How can a tenant?
Beneficiary, I believe. A beneficiary of the trust. If the individual, the grantor passes away, the beneficiary is a child, how could they,
Right.
live
Yeah.
in the trust,
That-
live in the co-op?
That would be a fact-specific question. I mean, because if Ron said, a child, again, the shareholder's family is usually permitted to occupy the unit. So, in that case, if it was a child, then there wouldn't be a violation. So I'd say it's fact-specific about what would happen upon death and who remains in occupancy.
George Whitman asks, when does the trust become financially viable? An apartment of X value.
It's viable once the asset is transferred into the trust. Let's say the co-op, it's transferred into the trust, new shares are issued, the asset is protected, the co-op is protected because Jeremy would insist on all of these protections, including the personal guarantee. So that's when it's viable, the moment the assets are held by that trust.
Okay, this is asked by Alexis Hill. She asks, upon my death, my co-op would be transferred to a special needs trust.
Mhm.
Will this cause the trust to owe income tax or any other tax? The value of the co-op is well below the current estate tax limits.
There should be no income taxes because nobody's earning income. There won't be an estate tax either if the special needs individual resides there. And we would try to get a basis step up. So based on current law, I don't believe there would be any tax issues. But under Biden's proposal, there may be a capital gains issue. We don't know what's going on with that yet. But right now, nothing.
I wanted to address a question that Mike Kurtz sent in prior to the webinar, which was if your corporation has a flip tax, does it apply when you transfer to the trust? And generally the answer is no. We understand that this transfer is only happening for estate planning purposes, so that a flip tax wouldn't be collected at this transfer, but at the ultimate transfer is when the flip tax would be collected.
Very good point, Jeremy. You don't want somebody not to do this because of a flip tax. And, they're really not changing ownership. They are, but they're not, so that's great policy. Yep.
Elise Karras asks, what are the options if the co-op does not accept the trust?
Well, Ron could speak more to this. You could speak about survivorship rights and things like that. But of course, the board is the ultimate decision maker. It's their choice to approve or deny any application. But Ron, go ahead. You want to talk about alternatives?
Well, I go into your office and plead. If there's a reason why I feel that the co-op corporation would be protected, I would make my case. Again, Hankin and Maisel, they're there to protect the co-op board. It might just be standing policy. and there might be nothing we can do. But, you know, to be honest, I don't think there's any real reason, you know, if the co-op board, the co-op corporation is totally protected, I don't really see why they should refuse, but it might be standing policy. There's not much we can do unless there's a meeting of the board and they make an exception.
And this is the last question. It comes from Jeffrey Mazel. It says,
Never
"Thank you
heard of
guys
them.
so much for this great presentation. I look forward to seeing you guys soon."
We do too.
So
Same
thank
here.
you guys so much. It's been a great opportunity to hear about trust from two experts. And if you guys have any final comments, please feel free now.
I'd just like to say thank you everyone for logging on. We will make this webinar available on our website and on our YouTube channel. I appreciate the support. And if you have any questions, please give us a call.
And I just want to thank you, Jeremy and Max. Thank you for inviting me to do this presentation tonight. I really do appreciate it. I want to thank Hankin and Mazel. And also, if anyone's interested in doing a trust, feel free to call us as well.
Thank you, Ron.
Thank you so much. Take care, everyone. Have a great night.
Bye.